you, Megan, and thanks for having me. And in the talk today, I will give some background on international human rights law. I'm not entirely sure how much you guys know about it, and you come from different backgrounds. But as well as that, I'm very happy to take questions throughout. And also, whenever I'm speaking to undergrads, I always say, if you have questions about, working in human rights too, I'm happy to take those as well. So as Megan said, what I work on in my dissertation is international human rights, abortion law reform, and feminism. So I'm looking at, I'm going to introduce human rights as a framework to address abortion, and feminism as a way to enhance that framework. So the roadmap here of what I'm going to talk about is, what is international human rights law? What are human rights principles? You might have heard the term a human rights-based approach. What does that mean? I will review international human rights standards related to abortion as a human right, and discuss opportunities and challenges for using human rights, and in particular in supporting abortion rights. And I'm going to explore how feminism can support and assist the development of this framework, in particular when it comes to abortion rights. So if we're to think about a human rights-based approach to abortion, you've all heard of human rights, and the view that I set out here is that human rights, they are inherent to all individuals, and they can be protected by both norms and process. So international human rights law, it lays down the obligations that governments have to act in certain ways, to refrain from certain acts, and actions to take in order to promote and protect human rights. And there are different systems to do this. I'm going to focus mostly on the UN system, but there are also regional systems in place. There's the European Convention on Human Rights, an African Protocol, Inter-American system. But my focus today is on the UN system and how that can be used to advance human rights. And with regards to human rights-based principles, this is a term that is used mostly in international development, and I think that it's not used enough and engaged enough in other human rights strategies. And there are things that I think, in one area where it is particularly important is around health and health-based actions for human rights. So there are principles like participation. What that means is engaging a wide variety of stakeholders when you're designing international human rights interventions or programs. And that's particularly important around health-based areas because it needs to be multi-sectoral and engaged. It's not just about lawyers or the activists, it's about the rights holders, other sectors, whether it's physicians, clinicians, broad spectrum of people that you want participation when you're designing human rights practices. Accountability means that there has to be some form of redress when things go wrong. A good practice is that there's somewhere for people to go. Non-discrimination means that in designing human rights interventions and practices, you need to be considerate and careful to ensure that your practices take account of where different groups are situated. So you help design practices that can reach those who are disadvantaged or marginalized. And empowerment means you're focusing on the rights holder themselves, and that the ideal human rights practice empowers the individual to claim their rights. There's often this view of human rights as some, whether it's big groups like Amnesty or either, big states intervening on behalf of helpless individuals. That's an old view of human rights practice. Human rights are inherent to the individual, and the individual should be able to claim their own rights. And the legal standards, that means, this is your basis. These are the norms that you use. And I'm just going to give a little overview here of the United Nations system. And I'm not sure if you can see it correctly, but basically there are these 9 treaties. So they're the laws on the books for the UN system. And states sign up to these treaties. And the ones in red are the ones that I will discuss more that are focused on, because these are the ones that have interpreted to recognise a right to a safe and legal abortion. They have been interpreted to do that. And so each of those treaties comes with what's called a UN monitoring system. And they are created to ensure a government compliance with the treaty obligation. So each one has a committee, and the committee's mandate is to monitor the progress in implementing the treaty. Before states sign up, they might have a lot of things that they have to do to sign up. But after that, there is a process in place whereby the states can be reviewed by a treaty monitoring body, which is a committee of independent experts from all around the world who assess how the state is doing. And these committees, they also have the authority to issue what are called general comments. So going further than the line that's in a treaty, a general comment will explain that in greater detail. So for example, the right to health, the protection of the right to health, what does that mean? So these committees, they take input from civil society groups. So when I say civil society, that's kind of advocacy groups, and individuals and experts in the field, and they produce these general comments. So how can these bodies support abortion rights? So they can create human rights standards that apply to reproductive rights. So none of those treaties that I mentioned include explicitly a right to an abortion. So, and historically, rights to reproductive decision-making, reproductive health and abortion, these were marginalised in the field of human rights. But thanks to the work of advocates in particular, and you've drawn on some of this in your population health course that you've been doing, that they have used these international tools to draw connections between other international human rights, whether it's your right to health, right to life, right to non-discrimination, right to privacy, right to be free from cruel and human degrading treatment, used those rights and made connections with a woman's right to have an abortion. And so they do that sometimes by having individual complaints. So that's like somebody taking a case to an international treaty body. There can be country inquiries where a group in a country can ask this committee to come and do an investigation. So to give an example of that, there were extremely strict contraception laws passed in the Philippines a couple of years ago, and they asked the CEDAW Committee, which is the Convention on the Elimination of Discrimination Against Women, to come and do an investigation. And they did, and they condemned the state for being regressive in this way, and have helped to work continuously with the Philippines to restore the law back to what it was, which allowed women access to contraception and removed third-party requirements, which is, the stipulation was that women had to, get permission from whether it was a spouse or parents, etc. I mentioned the general comments and concluding observations. They are when, as I said, the government has to go to the treaty monitoring body and explain what progress they're making in implementing a treaty. The concluding observations are what comes out of that process. So advocacy groups and individuals and the government will go to this treaty monitoring body committee in Geneva, which is where they are, and present what the state's doing well, what the state's not doing well, and the committee will then give recommendations on what the state should be doing. And that's been really, really helpful in the abortion rights process, and I'll discuss that. So it's incremental work all along. It's not that human rights things are set out in a treaty and then it happens and the states comply immediately. It's an incremental process, and the real work, and this is what I'm going to emphasize in this talk, the real work that human rights can do is when it's used by advocates as a tool to implement rights domestically. So this whole process, how it has played out in relation to abortion rights, at this time we can say in international human rights law that the international human rights bodies, they have supported the legalization of abortion in exceptional circumstances that are essential to protect a woman's right to health, privacy, freedom from cruel, inhuman, degrading treatment, and freedom from discrimination. So again, it's not that there's a right to an abortion set out anywhere, but this is what, thanks to the work of advocates and the treaty monitoring bodies, that the law now holds. Just remember, it's just those instances. It's not that there's a general right to an abortion in international human rights law. And they have also said that maternal mortality due to unsafe abortion violates a woman's right to life. They've come down strongly where states have third-party authorization requirements for abortion rights to health and life. So for example, again, where a woman has to get spousal consent, or a young girl having to get parental consent. So that's very, very common around the world, and the treaty monitoring bodies have come down very strongly on that. So that's kind of the status of international human rights law on abortion at present. And then this is just to give an example of where the committees have kind of spelled out, gone beyond what is there in the treaty, so spelled out what the right to health might look like in relation to abortion. And this was just last year, the CESCR committee, which is the Committee on Economic, Social and Cultural Rights, they issued this general comment calling governments to liberalise restrictive abortion laws and to remove third-party requirements. And these slides will all be sent around to you. Then, we have all these standards that I've just said, and what use are they? They're international standards. There can be governments hostile to women's reproductive rights anywhere. It happens where I'm from, in Ireland, here in the US, in countries all around the world. So we have these standards, but we know that abortion rights are being attacked. In some cases, they're being regressed, and sometimes we're moving backwards. So how useful is it? So you can think of human rights as, a legal tool, a cultural tool, or a charade. Many people think that it is a charade, that it's a talking shop, and that's all these bodies are. So we think as human rights as a legal tool. In that sense, you're thinking of those treaties as establishing binding legal obligations for the member states that have signed up to the treaty to take action to respect human rights. Or you can also think of human rights as a cultural tool. That's where my work focuses on mostly, and it's looking at human rights as a way of producing new understandings and a means of engaging with an issue. So that's like, is it a tool of social change? And that can include legal change and political change, but it's not viewing it as the same as there's a rule and the state's going to follow that rule because they're being coerced to follow the rule. The pressure is different because it's coming internally from cultural change. And I'll talk more about that. So if we are to think of human rights as a tool, we have these international standards, and advocacy groups have worked tirelessly for years to get those standards. But the ultimate aim of a human rights movement, no matter what it is to bring the game home domestically. So looking at how these human rights can be put into action at home to get guarantees from their government and to get access to rights from their own government domestically. So taking these international rights and bringing them home. So it can be a resource legally for advocates who can take a case internationally that they might not be able to do in their own country. So for example, that was one of the main reasons why abortion rights advocates began using the international tool, because our constitution precluded legislation to have access to abortion because it constitutionalizes a right to life for the unborn. So that meant that you couldn't have, a case wouldn't be successful. But they could go to the international arena and draw attention to the harmful impacts of a restrictive abortion law like that and show how it harms women, and then try and bring that home. So sometimes it's the only forum that advocates have. But lawmakers domestically, they may grow concerned at their international reputation because if a state is being, can go around the world that Ireland or the US is, denying women the right to an abortion, and that's a form of, cruel, inhuman, degrading treatment. They're denying women the right to health or the right to life, and sometimes states comply in that way. But as well as that, they, and the public as well may be engaged by things like that. But as I said, for the most part, civil society are the vehicle through which human rights are translated from the global arena to local contexts. And these standards are negotiated internationally, but really the stakeholders that they create are domestic. And what it can do for an advocacy group, if you could use this international standard, so it can focus your demand on a specific right, and that can be very helpful in advocacy. We're fighting for the right to health, we're fighting for the right to non-discrimination. Because it's hard sometimes to say things like abortion, it's quite stigmatized in many contexts, and if you can use this other lens, as I say here, it's really a legitimizing factor for advocacy groups who may not have had any space or been able to get access to the government or to the media because there might be such taboo around an issue. And that was the case in Ireland. The Parliament couldn't even mention the word abortion if they were dealing with abortion. They used to call it the substantive issue. But finally, after years and years, advocates, where they were able to get these international condemnations, that had to be addressed in Parliament. And abortion rights became something that parliamentarians were finally able to discuss. And it also can help build coalitions, which is really important. So, if we're to think of Ireland, there was one advocacy group, and it was actually a family planning or advocacy group that was in this field for years. And after they took their first case to the UN, they were able to get other groups involved. So whether it was the big groups like Amnesty or our equivalent of the Council for Civil Liberties. And so many more groups evolved and were created in response to how abortion had become a legitimate thing for women to ask for. Because before it was so stigmatized that it just wasn't a factor for people. Or big international human rights groups, so you can think about it with regards to domestic violence as well. International human rights groups didn't engage with domestic violence until grassroots organisations in different countries went to these international bodies and were able to show how a woman's right to be free from domestic violence was a human right. That wasn't considered a human right before. It was considered a private issue. And this is just an example of how to show that it's not just about a global arena. So I have the people, they're creating their report, and the government's creating a report to go to the UN. And then what really matters is this part where the people are getting back into Parliament and into society and into the newspapers. And that's really where the work is done. But of course there are limits, and I'm sure you've heard of many of them before, and they are real limits to human rights. There are gaps between these pronunciations of courts or treaty monitoring bodies and the realities of delivering healthcare services. And there's a limited enforcement mechanism. The UN doesn't have an army that we think of in enforcing rights domestically here. They don't have the same force. So that's why many people who work in this space don't necessarily think of human rights as a form of coercion, but as a way that you're creating stakeholders and impacting stakeholders on the ground, and they're the ones who are going to force the government to act. Although human rights justifications, they have been invaluable in abortion law reform, sometimes human rights law, it can appear unresponsive to local practices, and that's what we call an essentialist universal approach to human rights, and that's criticised worldwide. And if we think about, if we're talking about reproductive rights, their campaigns, they want to reach diverse populations with diverse needs, but sometimes difference can get lost in these universal strategies. And that is, you know, a big critique of international human rights law, that, you know, these norms aren't adapted to local conditions. So that can be, you know, creating a norm that's focused on, you know, liberty, you know, allowing somebody their freedom to do something. But in practice, somebody's freedom to do something can very much be impacted by what kind of resources they have and where they live in the country, and what their racial difference is. So that's sometimes why we say that international human rights law is essentialist, because it might assume that everyone is the same. And there's a strong critique of international human rights law that it has been an international law in general, in that it's patriarchal. As I said, none of these conventions discussed abortion rights, so it was a silence. These treaties were silent on so many women's issues. The exception of CEDAW, which was, you know, designed to combat that. And also that state action is the pinnacle of human rights law violations. That mostly it's been very difficult for rights holders to hold non-state actors accountable under international human rights law, because it's conceived of as a relationship between the state and the individual. But in practice, many of the rights violations that women endure are violations caused by, you know, whether it's in the home or in the healthcare setting. It might be the physicians who are denying them access to the lawful rights they have, or it could be domestic violence in the home. And that is changing, but it's a legitimate critique of international human rights law. So that's what I mean when I say that it reinforces a public and private divide. That the private was left alone by international human rights law, and it only focused on, you know, public abuse. And that it reinforces stereotypes of women. And that is a very legitimate critique of international human rights law. So if we think of women in international human rights law, or in international human rights cases, or a woman in a human rights report, these women are normally, you know, traumatized. They've had some terrible tragedy. They've been humiliated. They've been beaten, bruised, broken. But often, if we think of, you know, the man in international human rights law, you know, he's been fighting against his government, and, you know, he's going to be justified, and he still has agency and is strong. And that really comes across in the type of rights that women have in international human rights law. So if we think of the abortion right that is protected in international human rights law, we see, you know, a woman is entitled to an abortion under the law in cases of risk to her life or her health, where there has been an instance of rape or incest, or if the fetus has a fatal anomaly. Not the woman who just doesn't want to be a parent, who's making that decision to take control over her own life. It's only the women who can be conceived of, you know, in a tragic, traumatizing circumstance. They are victims, they didn't want this, rather than the woman who's taken action over her own life. And that creates a hierarchy of rights holders. You know, we demarcate deserving and undeserving women. And that's problematic for feminists who are looking at human rights law to recognise women as humans, not just victims. And there's also a concern that, you know, rights discourse is you know, it's not a one-way street. Sorry, I'll just take your question.
Yeah, can you just comment a little bit more on why the human rights justification hasn't been extended to women, not in those, like, extreme cases?
Yeah, so, you know, it's speculation at this point, but, you know, last year I interviewed the CEDAW committee and, you know, went around and asking them this. And in part of it, it is they don't want to be seen as going too far. And they really want to stick to these exceptional cases because it's easier for them. You know, they don't want to lose all their legitimacy. And you can have some, you know, sympathy with that view to a point, because these committees do fight for legitimacy, to be seen as an authoritative source of international human rights law. You know, they want states to comply, and they think that they would be going too far to be pronouncing something like this. So that is, you know, my assessment of it. Also, you know, there can be, these committees are international, so there are contrasting views on what women should be entitled to. So not all the committee might be in favour of supporting abortion rights, but really it has been a very conservative approach, and they haven't been used to dealing with women's rights in the same way. So that's even CEDAW, who, even though theoretically they realise, this is a matter of women's equality and autonomy, they're the Committee for the Elimination of Discrimination Against Women, but they don't want to put it in those terms because that means access to abortion. So instead they focus on the right to health. So a woman, if her health is at risk, she can have an abortion. Again, it's not that a woman can have an abortion and her right should be protected because she wants one. It's that there's some other circumstance that makes her appealing or a worthy subject, and that is a very legitimate critique. Oh, I did this one. There we go. So just to talk a little bit about some successes. So the rights can also be translated judicially. So for example, in these two countries recently, where there have been very restrictive abortion laws, it was the judiciary who referred to the international standards and pronounced that the domestic law was in violation of international human rights. And there are two recent examples that were quite surprising to the world, basically, conservative countries who had very strict laws. And that doesn't happen everywhere, and as I said, my work and my approach to human rights is to think very much about how advocates change domestic politics, rather than, again, thinking of it as an elite thing between an international court and then a big domestic court. So for example, in Ireland, how human rights have been used, so I mentioned that the advocacy groups have really, in the past number of years, they've gone to every single one of those 5 committees. So the Committee Against Torture, the Committee for the Elimination of Discrimination Against Women, the ICCPR, which is the Convention on Civil and Political Rights, the CRC, which is the Convention for the Rights of Children, and the Committee for Economic, Social and Cultural Rights. So they've prepared reports in consultation with the government and with women, and gone and done consultations around the country and mapped out the harms that women were experiencing, which often isn't done. People don't want to talk about abortion or the impacts that the lack of it has. Just to step back a second, abortion is illegal in Ireland, and with the exception of where there is an imminent threat to the life of the woman. And what that has severe impacts on women. What women have traditionally done is gone abroad to the UK, or more recently taken the abortion pill. But taking the abortion pill has a risk of 14 years imprisonment if a woman is found to have done that, and anyone who assists her. Yeah.
When it says in Ireland, for imminent to the mother's health, does that mean immediately if she could hemorrhage right there a medical, or is it more long term, say she has mental health, severe mental health issues, so that wouldn't be taken into account?
The first one.
Okay.
So it's a risk to her life at that instance. It does include a risk of suicide. Because the law has been so strict, even though that is the law, it's extremely rare that a psychiatrist or there's a committee that has to approve this, and there's maybe about 12 every year. And there are numerous situations where women have been denied access, or there was even a case last year where a young woman was sectioned instead of being given a lawful abortion. She was entitled to a lawful abortion, but they put her under control. So these strict laws have really damaging impacts, and going to an international body may be the first time that this gets aired, because it was such a taboo thing for so many years that your local politician didn't want to talk about it. But when I say that they have set an agenda of law reform by using these human rights processes and bringing them home, this situation is about to, I'm going to be optimistic here, dramatically change in Ireland. We do have a situation where the Parliament is discussing law reform at present, and there will be a referendum to change the constitution, and that will be put to the people. And whether or not that passes is, you know, we won't know until May. But if you were to consider the fact that for years any referendum or law was just to take away those rights, so to take away the right to an abortion, life-saving circumstances, in the case of suicide. So there were 2 referendums to try and do that. This is the first time there will be a referendum to give women abortion rights. And that's a huge shift from a time where parliamentarians wouldn't even discuss abortion at all. Yeah.
Are there other, so I'm assuming that this is based on Catholic influence that these rights are, or are there other forces pushing it, and then are there other health conditions that are sanctioned or legal rights that are sort of set in stone by the Catholic Church that would butt up against human rights law?
So certainly part of it, you know, it comes from Catholic doctrine, but this law was enshrined in 1983, and you know, my research shows that it was more of a reactive measure to broad liberalisation, mostly of women. So this was a time where the country just allowed access to contraception. We joined the EU. There was now equal employment laws, which hadn't existed in the country. There had been a marriage bar on women. You know, once you got married, if you worked in the civil service, you had to leave your job until 1977. And there's also a deep history of kind of criminalisation or exile of unmarried pregnant women. So I don't know if you've heard, but there's a big history in Ireland of where unmarried women were put into what are called, they were called Magdalen laundries for fallen women. And they were sent there by their family and by the state, and that's where they were put for the rest of their lives, and possibly their children taken from them and sent abroad. So it's part of a history that it's, you know, was certainly part of the country's national identity, you know, to describe this as, you know, we're very, very Catholic and pure. But all these markers of Catholicism were directed towards women, not society in general. So, you know, the idea that, you know, this was our most Catholic times are probably, you know, the least Christian, if you're to use the term, you know, the idea of, you know, being caring, or it was a very lonely place for, the state was very lonely, or people were exiled. So that's kind of continuously what has been done for, you know, women who don't want to be pregnant, send them abroad, and you're just able to turn a blind eye. The rates of abortion in Ireland are not lower, for Irish women are not lower than anywhere else in the world, even though we have one of the strictest laws in the world. And contraception, just to get back to your question, you know, it has been legal. So there aren't, since the late 1960s, but it was, you know, different levels of access. That's kind of the only healthcare issue that has been as dominant. But there are, you know, the hospitals are controlled mostly by Catholic boards. So that will be an issue if the law is implemented. You know, how much state control they can have. You know, there will have to be legislation passed to say that, because they are publicly funded, but they're controlled by the Catholic Church. It's the same with the education system. So it'll just require law reform if that's to happen.
Is sterilization legal?
Sterilisation is legal, but one thing that did exist was brought to light by an international body. A group took a case. It was very high levels of symphysiotomy, which has been linked to, you know, a non-desire to carry out C-sections, and linked to, you know, some of these. It was part of the ethos of some hospitals to have forced symphysiotomy. So that's in the past. It doesn't happen now, but it happened until the 1980s in certain Catholic hospitals. Yeah.
The law being put forth that they're going to vote on in May, what parameters are around it? Is it just first trimester pill?
So it is, so that what happen in May will be a referendum to get rid of the amendment to the Constitution that says there's a right to life to the unborn that's equal to the right to life of a woman. But what they have said is they're going to have legislation alongside that. People won't be voting on it, it'll be the Parliament voting on it, but just in the interest of clarity, people know what they're getting into. And what that proposes is unrestricted access up to 12 weeks, and then after that, fetal abnormality and health and life. Yeah.
Are there any current or proposed exceptions for like cases of rape or incest?
No. So the travel to England has been an option, but often, people can't travel to England. So for example, there are like terrible stories of, asylum seekers in Ireland because they don't have the permission to leave. And a lot of people get to the country and they've, gone through horrific abuses. Some who have been raped and they can't access an abortion. If they leave, they won't get back in. So there's been just terrible cases, and it's an underground network to try and help these women get out and be able to come back in, but that's not sustainable. Also, it costs a lot of money to go abroad because you have to pay for the abortion in England. So women who live in England can have an abortion under the NHS paid for, but Irish women can't. You have to pay to get there, to stay there. And then taking the abortion pill is a cost-effective way, but it is, it's only now that people can know about this to the same extent as they should, and it's very risky because if you're caught, you could be prosecuted. Yep.
So I know that you said that you would get like 14 years in prison if someone found out that you took the pill, but what about like if you had successfully travelled to England, gotten an abortion, and then came back? Would you still be like?
No, so the irony of the law is that the Constitution actually says you can go abroad. We're happy to exile you, and you can go and have your abortion in England. You just can't do it here. So as I said to Megan, it is very much has been traditionally caught up with this national identity of we're a pure nation, but we're just happy to export women in their time of need. Yeah.
Sorry, I might have missed it, but so if you get like jailed for 14 years for like if someone finds out you took a pill, like how do they get access to the pill?
Oh, online. So there's a group called Women on Web, and they were a group. It was set up by a doctor from the Netherlands, and she had a ship. I would dock in places to give women abortions, and then as technology improved and the abortion pill was available, so it's sent online. So your abortion pill might not arrive to you because it might get caught up in customs. So you really don't know, and it's obviously not a satisfactory way for women to access. Yes?
I think I must have misunderstood a previous comment from you, but I thought Stella Casey, the NP, had gotten an amendment passed that the NHS would in fact cover the cost of an abortion. That still disproportionately affects women who have to travel and all of those problems. But did I misread that?
So that was for Northern Irish women.
Ah, okay.
Because they are part of the UK. So Northern Ireland has different laws, and they also do not permit abortion. But in the UK, you can't have an abortion legally. So Northern Irish women also had to travel, but just last year, an MP succeeded in passing an amendment to say that those women would not be charged for their abortion. So they still can't get one in Northern Ireland, but they don't have to pay now. Yeah.
So I was able to do some research in Argentina, so they have similar laws on, and it's changing recently, like to include like a woman's health, but one of the problems is that in a lot of areas, there's still like this social taboo about it. And so some providers, they can like consciously object to performing an abortion. So I imagine in Ireland, maybe in the coming years, if laws do change, there still might be that problem. So I was wondering, like, how do you think international conventions can speak to that as in like ensuring this right for women, even if they do legally have the right, like how does it actually get ensured for them?
Yeah, and that's key to the whole process, and why I take the approach, and lots of people do, that human rights, it needs to be seen as a cultural tool, that you're trying to change how society engages with this issue, not just the government. So conscientious objection, it's become a huge issue throughout Europe. And one way I think you can safeguard against that legally is how you frame the right. So this is where a lot of the feminist work that I do comes in. is that if this is framed as a right to equality and non-discrimination, that there is afforded a lot higher protection than the right to privacy or even the right to health. So the state can have an awful lot of justifications for why it is not imposing that. And somebody's conscientious objection is a legitimate reason for the state not to have to protect that right. But if it's a matter of autonomy, allowing that autonomy and equality to be overridden in international law is at a higher threshold than privacy or health or life. And also, but another part is it depends domestically how successful advocates are at ensuring that there are not laws that allow extremely broad conscientious objection. And international human rights law is getting better at finding a violation in those cases where the state does allow for very wide conscientious objection. But I think that what would be helpful and what can be helpful is if we move to viewing this as an issue of non-discrimination and equality, not just about exceptional things. Sorry, you?
Sorry, just about the underground movements that promote abortion. For example, you talked about the women on web and about the ship, because I hear that also happens in Brazil, where there's a ship that docks in international waters and women can go get an abortion. Did you think such underground movements serve to undercut local advocacy efforts? For example, the government be like, yeah, you're lobbying, but we know women find a way regardless to get an abortion, so why should we make it legal? Like, does it counter local advocacy efforts?
So what's interesting is that if I'm to consider Ireland, where I've done most of my work, what really seems to have moved a lot of these legislators. So they've had people coming into them for the past 3 months, a special committee, including Rebecca Gompertz, talking about what is happening. So women having illegal abortions. And it does seem to have moved Parliament to consider this is happening on our shores and we have to deal with that. Now, it's not a guarantee that a legislator might respond in that way, but in the Irish context, it has become something of, oh, are we just going to keep burying our heads in the sand like we always do with difficult, conscientious issues around gender? Or are we going to legislate for it? And, you know, I would be concerned about some of the advocacy around that because it makes it seem like there are, you know, they talk about women bleeding by themselves and, you know, being scared, and that narrative is taking over, like the abortion pill is bad and unsafe, and there's a danger that that narrative could take over when in fact it has been shown to be very safe. So it's very difficult as an advocacy strategy, but the idea that, you know, with the ship or them accessing the pill online, it hasn't been shown to negate law reform efforts in the Irish context. It's supporting it. Yeah.
So has there been a correlation at all? Because I would assume that the amount of children, kids, people who are in orphanages like rise because of this abortion law. So maybe something that could help would be, although I don't agree with using population control as a way to like advocate for like reproductive rights or women's health, I feel like that would be useful in like shaping their minds, since they're not necessarily going to want to do it on their own. So has there been any studies done with like these abortion laws and the rise of like people in orphanages and how to deal with that and population control?
So the irony of these abortion laws is that it doesn't reduce abortion among Irish women. The rates are the same worldwide. So, you know, women have either taken it into their own hands by having abortion pills, sometimes unsafe abortions, or going abroad. So there isn't this ramification of women with unwanted pregnancies putting them into orphanages or up for adoption. It's actually very rare.
No, it hasn't risen at all. Okay.
No. And it's rare in general for, you know, a woman who has gone through a pregnancy. Like worldwide, rates are quite rare for women to put those babies up for adoption. If I was just to continue a little bit about how feminism can help. So I mentioned that it can help improve the legal standard internationally, to support an unqualified right for women in international law. And I propose that it can do that by focusing on equality and non-discrimination as the underpinning to the abortion right, rather than the exceptional rights. So I said life, health, right to privacy. And they can support that, and there certainly are violations of all those rights. But if the underpinning is stemming from the gender equality impacts of this. So, abortion, a feminist approach reveals the gendered implications of a law or a rule, so that's the impacts on women, and also can show the purpose of the law. And as I got into a little bit there, there's the criminalisation of abortion in Ireland. It's part of a much broader environment than the healthcare setting, or than women's lives at stake. It's about controlling their sexuality and their roles, and that's where the law stemmed from. And there isn't, international human rights law at present hasn't engaged with that narrative, with the exception of a recent case of an Irish woman, Amanda Mellett, who took a case where she was denied an abortion, where she had a fatal fetal anomaly, fetus that wasn't going to survive to term. And in a kind of not the majority opinion, but one person on the committee did say that this was very much tied to stereotyping women as an instrument. The fetus wasn't going to survive, but she was going to be forced under the law to carry it to term. And that's viewing her as a reproductive instrument. So that was quite, surprising language from the committee, but it shows that their mindset might get there. The abortion rights movement, it is a struggle for women's equality. So, women's access to abortion is key to their ability, to participate in, with what we call the economic or political life of a nation. But it's also about, respecting a woman's vision of her own life. But also, if we're to think back to as well what I said about implementing laws domestically, a feminist approach is a key part of a feminist approach is to look at the context in any given, whether it's jurisdiction or area. And that means engaging with the social, political, and historical aspects of this as they relate to women. And that's key to showing why you need unqualified abortion rights in Ireland, as my research shows, or worldwide, is showing how these are tools and they're a manifestation of discrimination against women and historical subordination of women, and using those insights in showing the gendered impacts on women and the purpose of these laws shows why you need to expand the right, not just to afford it to a certain category of women. And in the domestic context, it can be very powerful to engage with the local history and meaning of abortion, tackling the root of the problem rather than just offering technical solutions, which can be very, very helpful. But if you want long-term human rights impacts and the societal change that's necessary, I propose you need to engage with the actual roots of the problem and the mandate for gender equality that exists and comes from these advocates who are pushing the reform. That it's not seen as some global arena telling a state what to do. This is coming from within, and this is part of the history and the struggles of Irish women. And I'd love to continue questions. We started. Yes?
So the U.S. Right to abortion is not based in human rights theory or feminist theory. It's based on the right to privacy, which some people, even abortion advocates, feel like is a weak lever, I guess. Or how do you think this compared to utilizing a protected aspect of the Constitution? What are the strengths of this compared to, or the weaknesses of a human rights approach using a feminist one?
Did you say human rights versus a feminist approach, or just
human rights using a feminist approach
versus a
constitutional? In the U.S. Constitution, we don't have a right to equality, or we certainly don't have a feminist approach, but we were able to the Roe versus Wade was able to capitalize on this right to privacy to create a law that stood for 45 years. So how do you think that compares to a human rights approach in a conservative country that may not accept gender equality before?
Well, with regards to a human rights approach, so without the feminist approach for a second, it's being taken up by advocates more and more, and in particular it's being taken up with advocates to show how rights mean nothing without resources. So, for example, the Center for Reproductive Rights has done a lot of work in using international human rights tools. So, for example, in the Rio Grande Valley, and in showing how this right in the books that exists is not operational for marginalised communities who don't have access to private facilities or funding, and also in putting it into a context of a woman's right and to her equality as well, connecting it to issues around her access to contraception and real sex education, which doesn't exist in many parts. So in that sense, it's a good advocacy tool. It's only starting to be used in the US. And with regards to a feminist approach, which at the moment they're not fully connected, the human rights approach and the feminist approach. But there has been, quite good, in some parts, like good language, we'll say, from Supreme Court judgments to a point in looking at how, the gendered implications of abortion law. So the Casey decision, Ruth Bader Ginsburg, before Ruth Bader Ginsburg, she's going to talk about the feminist, come at this from a feminist perspective, and looking at equality, but they don't do it under the 14th Amendment. They put it under, due process, and so the language can be quite similar in talking about a woman's autonomy and her ability to access, political life, access the workplace, but it's not rooted under the normal equality term in the Constitution. They do it under this liberty, autonomy element. So I think part of that is because it began as a liberty privacy right. So it's like reimagining liberty and privacy by putting this in. And it was the same for same-sex marriage, that again it was seen not under equality, but we conceive of it, and a lot of the language in the judgment you would think, oh, this is because it's for equal marriage, but the court hasn't said that. They have said that this is part of someone's fundamental dignity and their autonomy. So it's a different process, but I do think getting that language in is really important. So I would obviously prefer if the US Supreme Court would engage with the fact that this is about this, the history in the US is very similar of this being about stereotyping women to fulfill certain roles in society, the roles of motherhood, and those who are deviant should be punished. It's a very similar history, not tied necessarily to the US national identity, but it was, again, a conservative backlash. And it's regrettable that, that hasn't been developed as much in constitutional jurisprudence, and prior to the current administration, it seemed like they might get there, depending on the Supreme Court, particular with regards to Elena Kagan and Ruth Bader Ginsburg on the court, but it has backtracked. It's likely to backtrack, but there is encouraging language sometimes, but it remains to be seen how it's going to develop. Yeah.
So, kind of on that note, so we're coming up on the 45th anniversary of Roe v. Wade, and we've had all of these attacks now recently within the last couple of years, especially under this administration, on abortion rights. So how do you think that abortion right advocates can try to shift the dialogue and build capacity for this more feminist-based framework when we're constantly reactively trying to stop even more restrictive and more harmful legislation from being passed?
I think that's in part, it shows in part why the underlying framing is so important. So abortion, initially it wasn't conceived of necessarily a woman's right, as so much of the language was about a physician's right to care for their patient and their autonomy and liberty, rather than a woman's ability to live her own life and to be an equal citizen in the state. And I think that engaging with what women's rights activists are actually struggling for, which is equality, and pushing that in that circumstance, like I said with the conscientious objection, that under the law, the ability to cut away at equal protection is a lot more difficult and it's a lot more stringent. Because what you're at present is states are allowed to undercut this right unless it's seen as too much of an undue burden is the language that's used. So they're permitted to do that under the law, and that's how the law developed. But if the law had developed differently, there wouldn't be the same legal sanction for states to do that. And you will always have conservative backlash, and some people say Roe v. Wade shouldn't have come from the courts, it should have come from society. There's evidence to show it was coming from society, but I do think that if you tie this to a mandate of women's equality, women, as their access to contraception, access to sex education, it's holistic. It's not just about this one circumstance, disastrous time in the life, or about a physician being able to act. And with regards to the tools that they are using, the Supreme Court is one tool. More and more states are working locally, whether it's in their own cities, to get ordinance passed, or trying to support providers. And that's part of, a human rights-based approach, without calling it human rights, is engaging at this local, multi-sectoral level. And that's what advocates are doing more and more, but of course facing incessant backlash. And that's a worldwide phenomenon. You can't necessarily safeguard against all backlash, but you can have tools in place to continuously mobilize, to fight against it, and to have stronger laws in place that could fight it.
There's a really great documentary that came out last year that's available on iTunes called Birthright. I don't know if you've seen it. It's called.
You were telling me about it, yeah.
Birthright, a War Story, and it is about how framing abortion rights in the U.S. Not based on women's equality has enabled the right to encroach on, or the religious right, on other reproductive freedoms. So outside of abortion, the fact that that trap laws, which restrict access to abortion, have been so successful, has impacted women's ability to choose how they want to deliver, where they want to deliver, whether they want contraception, whether they can get sterilization. It is really, it goes into the background of how the opposition to abortion was framed, similar to what you described, as a backlash to liberalization. Essentially, people thought the fight was done after Roe v. Wade, and about 5 or 10 years later, well, early 80s, the religious right started coming up with ways to work around the abortion laws. So I'd recommend it. It's on the Deeper Exploration site. But thank you, Christine.
Thanks for having me.
And you'll be back.